number 50, the people of the state of New York versus Twanek Cummings. Good afternoon, counsel.
Good afternoon, Your Honors. I'm Benjamin Weiner on behalf of Appellant Twanek Cummings. I'd like to please reserve 2 minutes of my time for rebuttal.
Of course, sir.
Thank you, Your Honor. In this case, the prosecution took a judge falling ill as an opportunity to get a second bite at the apple.
But counsel, in a case, can't a party request that a judge reconsider a prior motion or a prior decision?
Sure, Your Honor. The legislature...
Why then can't, under your analysis, the substitute judge do the same here?
I'm sorry, I just want to make sure I understand the question. You're asking about the same judge on a case they could reconsider their motion, and so why can't a substitute judge?
Also reconsider the motion. Correct.
Well, Your Honor, when it's a single judge, the core interests that underlie the law of the case doctrine just don't apply. You don't have this kind of forum shopping that essentially occurred in this case.
Well, they didn't cause the judge to become ill or seek this particular judge. I guess what intrigues me is if we agree with you and we reverse on that ground, then it goes back for another trial and there's a whole other judge, then I assume you would agree they can make the motion again, just like they did the last time the trial wasn't.
That's right, Your Honor, but that...
So what's the point of that?
It's necessary to enforce the rule that this court ratified in Evans and reiterated in Bilski, and that protects critical interests in terms of finality, in terms of preventing the parties...
What about the distinction between evidentiary type rulings and other types of rulings? Why shouldn't we adhere to that?
Well, Your Honor, nothing in Evans or Bilski suggests that the limited exception in Evans should apply in any situation other than a retrial. And that makes sense. After a retrial, it could be years later until the next trial. It's going to be very difficult for the parties to even know...
These are discretionary rulings, counsel, right?
Well, Your Honor, they are ultimately subject to the judge's discretion, but the judge had exercised her discretion in this case. She had
So that's it? Cemented in stone?
Well, it is, Your Honor, especially in a case like this where absolutely nothing had changed in between the time she originally made the decision and the time Justice Allen, the substitute judge, reconsidered it.
You're not arguing there's any actual prejudice, that is, you had planned your case a particular way, and then because the ruling changed, you had already done something that you were, would have not done that way, right? There's no argument like that.
No, but this court has never suggested a prejudice requirement. That would be an independent due process issue if the parties had detrimentally relied on a judge's ruling and then it changed. But the rule here under law of the case is just a determination that the judge has made that the parties had a full...
Is it your position, let's go back to something you said before, is it your position that Justice Pinkles had not fallen ill and had stayed in the case? The people couldn't ask her to reconsider her prior decision?
They could, but they absolutely wouldn't have done that. There's no way they would have done what they did here and resubmit the identical motion.
Counsel never asked for reconsideration, thinking the judge has made a mistake, let me try again.
They might, but the judicial efficiency concerns that lie at the heart of the law of the case doctrine...
The bottom line is they can reconsider. You could come in, it happens all the time, you're a trial judge, somebody will come in and they'll say, Judge, there's a case I failed to mention to you on this ruling on 911 tapes. I want you to look at this and maybe reconsider this case. And the judge may or may not do that. And it would be not only proper, but probably required for the judge to do that, wouldn't you say?
Well, again, the legislature has established a procedure for a motion to reconsider, a motion to renew, when there's new circumstances that arise, when the court overlooked some controlling law.
But isn't in this case really, the law of the case thing, this is a convoluted case where we have 3 judges on one case in unusual circumstances where it's twice not admitted and then finally admitted. Ultimately, though, aren't we really talking about whether or not the cited utterance exception was properly applied in this circumstance?
Well, it was not properly.
Okay, so
in this
that's really what we're
circumstance.
ultimately concerned with here, right?
No, Your Honor. The law of the
No?
case in doctrine independently barred Justice Allen
Well,
from
do me a favor.
reconsidering.
Do me a favor. Go to the cited utterance. Go to the cited utterance argument, okay? Because I understand your argument law of the case, but I don't want us to not hear from you on this point.
I want one more question on this, excuse me. So are you suggesting that if I'm the trial judge and I make an evidentiary ruling and I go home over the weekend and I'm thinking about the trial, that I can't return to court on Monday and say, I've reconsidered this, I'm not comfortable with my ruling?
The court can absolutely do that. They can reverse their own rulings. And again,
So
part
what
of
is
the
the
law of the.
difference? What's the
Excuse me, Judge, I'm
difference?
sorry.
What is the difference?
The difference is that in that case, you don't have a judge of coordinate jurisdiction sitting in what is essentially appellate review.
Why are you
of
calling this a judge of
coordinate
coordinate jurisdiction? Why are you calling this a situation involving a court of coordinate jurisdiction?
That's the language that the court used in Evans, and that obviously applies
That's when we're talking
here.
about a different court that is parallel to the court you're in, not the same court with a different judge replacing the judge.
And it applies with all the same force in the case of a substitute judge. This is another judge who's a member of the same court, has no power of appellate review over the initial judge that made the determination, and so it is a judge of coordinate jurisdiction under Evans. I do briefly want to get to.
Yes, let's get to the excited utterance.
The underlying issue. This was a statement made by someone who is completely unidentified. Not only do we not know their name, we have no idea who they are. We have no idea what their relationship was to the underlying issue. The statement itself doesn't even
Well,
describe
don't
an
we
event.
just really need to know whether they personally observed it? We don't need to know all those other things, do we?
But the fact that we don't know any of those things, the fact that we know so little about who this person was, means that the court can't infer that this person personally
What if
observed
it
the
was
event.
within 10 seconds of the shooting? Would that make a difference?
Well, that's not the case here
No, I
initially.
know, but if it was, I mean, do we have to do any line drawing here?
Well, I don't think that would really matter. Maybe if it was in 10 seconds, the person was turned around and they heard, or it was something they assumed to be the case. And again,
Well, we've already said it's not about the amount of time.
it's not about the amount of time for the excited
And
piece.
it's not about whether or not they're identifiable. Judge Stein really identified it. It's the personal observation. And the language is sometimes a little different. They talk about any basis to establish the declarant's personal knowledge. Now, there's an unknown declarant here who said it's Twanek man. Is there any basis in the record to establish that declarant's personal knowledge? And if there is none, is there any place you can point to that we should look at to say there's none here, Judge, and this is where you should look?
There's none, Your Honor. And I'd point you to the statement itself. There's almost no content to this statement. There's nothing the court can latch onto to say, oh, this is a statement of someone who has personal knowledge, who personally observed. And I'd also.
Well, you've got a shooting on a street, right? You've got the officers say there are people who are aware of this. There were people there to begin with. There are people who would then start congregating. So we do have some sense of there's a chaotic situation.
Right, Your
And
Honor.
if nothing else, it seems the remark, it's Twanek man, seems to suggest that at least the individual knows the defendant. Your point is whether or not they saw anything related to the shooting that connects the defendant.
That's right. And the testimony here, I'd just like permission to answer your question, Your
Yes,
Honor,
go ahead.
is that minutes after the shooting, when the police arrived, there's a huge crowd forming of people who weren't there at the time of the shooting itself. We have no idea who the declarant was in this case. If he was one of those people, if he was somebody else, we just don't know. And so this doesn't meet the threshold reliability
What if the
to be
statement was,
admitted.
oh my God, I just saw Twanek shoot at this guy?
That would be a substantially different statement, Your Honor. I saw him shoot this guy. What he's saying in the statement itself is, I saw this. I have personal knowledge. That's absolutely not what we have
So you're not
here.
suggesting we need to know who this person is or what his background is. You're just saying that the content or the circumstances may, in and of themselves, demonstrate that.
Absolutely, and it doesn't here. The content of the statement doesn't do that here, Your Honor.
Thank you.
Thank you.
May it please the court. My name is Ross Mazer for the respondent, the people of the state of New York.
Mr. Mazer, what facts allow this inference to be drawn that the speaker had personal knowledge?
So before I answer your question, Your Honor, I would just say that the lower court's finding certainly has support in the record, and as a result, it presents a mixed question of law and fact, which, so long as it has record support, is beyond this court's further review, and I think both sides agree on that standard. Responding to your question, I would highlight 3 reasons to support the lower court's finding of personal knowledge. First of all, the characteristics of the statement itself demonstrate that the declarant was speaking from having observed the shooting and then having recognized the shooter. For one thing, this is the unusual case where the statement was actually recorded in the background of the 911 call, and so the jurors could rely on their common sense and their common experience to determine whether, as the people argued at trial, the tone and the content of the declarant's statement was consistent with someone who had just seen an ambush shooting of 3 people.
That's true. If there are 2 equally reasonable inferences, okay, is that enough to get you over the line? In other words, perhaps one could hear that statement as indicating that there was personal observation, but it's equally possible that they would say, no, that doesn't tell me anything at all. So is that enough?
In this case, first of all, I'd say that I don't think the inferences are equal, that the inference of personal knowledge is much stronger. But responding to your question, certainly in this court, if reasonable minds could differ about the inferences to be drawn from the established facts, that would present a mixed question of law and fact beyond the court's review. But even at the trial court's level, the standard that this court has established in Fratello, and I think both sides rely on Fratello to provide the relevant standard, is whether the circumstances permit the trial court to make the reasonable inference that there's personal knowledge here.
And doesn't that relate to the minimum standard necessary and get us beyond a mixed question and move it into a question of law? I'm sorry.
Well, certainly if at the margins any question of fact could present a question of law, but if reasonable minds could differ about the inferences, then it's just a mixed question. And I would point to the remarks of Justice Merchan at the end of the first trial, where he said this was a close case and reasonable minds could differ. So even that one of the judges who excluded the statement would have presumably acknowledged that it presents a mixed question upon review before this court.
Counsel, going back, I think earlier, I think the chief judge was asking, other than the tape itself, so you have the timing of the statement based on the 9/11 call, and you have the statement itself, it was the defendant. What else is there to provide any background to who made that statement or what the person who made that statement saw?
So in addition to the tone and the content of the statement itself, there was the fact that the statement was made immediately after, on the heels of the shooting. It's undisputed.
But let's say it's a rival gang member. It's, I'm not saying there's gang involved here, but it could be the shooter. It could be, you have no, and I agree this isn't necessary, but in many cases you see you have at least the identity of the speaker, so you can extrapolate from that. You have someone who could at least say, I saw that person at the scene and they witnessed it. You have nothing here. You have nothing except a voice on a tape saying it was a very strong accusation, which is very, prejudicial, and evidence could be prejudicial, and I mean that in a negative way, but without any context provided as to what that person actually saw, who that person was. I'm having some trouble understanding how, as a matter of law, you could say there was a basis for admitting that.
Respectfully, Your Honor, I would disagree with your characterization. not only was the statement made immediately after the shooting, but it was made at the same place where the shooting occurred. And we know that
But
because
there's video surveillance cameras, and I mean, maybe if there was a camera showing the shooting and showing a person right there who clearly had a view of the shooting, and you could see them saying something, well, that certainly might be a closer case.
It's a street, right? It's a public street.
it's a public street in the middle of a sunny afternoon, a busy Manhattan street corner, and the surveillance video, while it certainly can't identify who the declarant was or even whether the declarant was one of the bystanders pictured in the video, shows that a number of bystanders were well positioned to observe the shooting.
But it's no way to know whether it's more likely or not that he just walked up there after the shooting and didn't see anything, or he did. There's no way to, there's nothing in the statement itself that enables you to make that determination without speculation.
Well, I would say that you're drawing inferences from established facts. It's not speculation. To finish answering Judge Garcia's question, we know that the declarant, 90 seconds after the shooting, was standing at the shooting site, at the corner itself, because for his voice to be overheard on the 911 call that the victim was placing, or on the call that we can hear the victim screaming on, he had to be right at the corner. And if we know exactly where he was 90 seconds after the shooting, we know about where he was 90 seconds before the statement when the shooting occurred.
We don't know if he was bending down to tie his shoes or had his back turned and was talking to somebody or buying a pretzel from a vendor. We have no idea.
We don't know that, Your Honor, but the jurors can listen to the statement and gauge the
Couldn't they quite simply just say, all right, I listened to the tape, and the man's talking on the 911 tape, one of the victims, and you can hear, it's kind of difficult in the background to hear, it's Twanek, man. I couldn't tell if that's Twanek or it's Twanek, but nonetheless, listening to that tape, I couldn't see where that would illustrate the basis of a factual assertion that his statement rested on his personal knowledge. You can't identify the person. He's making a factual assertion, that's clear. Twanek did it. You don't know if somebody else told him that Twanek did it. I just can't find the basis for this factual assertion, and there's no other surrounding circumstances that seem to support it. The other evidence of the case is the video and the fingerprint, and those are not good for the defendant. But in this particular piece of evidence, I fail to see where it is. Tell me where the basis is, where we should look in the record for the basis for this factual assertion that this unidentified person made. Where do we look?
Well, I would
Is
say.
there anything beyond the 911 call, I guess is my question to you.
Well, I would say a couple of things, Your Honor.
Well, to answer that question, is there anything beyond the 911 call that we should look at to identify what the basis for this factual assertion is?
Beyond the 911 call, there's a lot of extrinsic corroboration in the record.
Okay, that's fine. Tell me what you think it is.
Well, and this goes to harmless error as well. But the trial judge would certainly be justified in considering the other evidence, circumstantial evidence of identity, showing that the
But that won't tell you the basis for the factual assertion made by the unidentified person on the 911 tape. That'll link up the defendant, which I agree with you it does.
Well, it would undercut any alternative to personal knowledge that's premised on an alternative to personal knowledge that presumes, either a mistaken identification or a bias to falsely accuse the defendant, Twanek Cummings, because it buttresses the reliability of the statement.
Mr.
Let me ask you
Mazur, let's tease out the harmless error argument a little bit, and let's assume for a moment that the statement is inadmissible. What evidence do you offer up in support of a harmless error finding?
So in the alternative, the appellate division was certainly right that the other circumstantial evidence of identity was overwhelming, that you could excise the statement, and there'd be no reasonable probability that the jury would have acquitted. First of all, the cell site evidence showed that the defendant was with Hamilton, the undisputed driver of the getaway vehicle, both before during
Well,
and
does it
after the
show
shooting.
that he was with him, or that at least they were in close proximity because they were bouncing off the same cell towers?
Well, that they were in close proximity, but that they also.
Well, probably a
you know,
lot of people in close proximity at that time, wouldn't you think?
I wouldn't think that there are very many people that travel, the route that the two of them traveled from, near 120th Street near defendant's apartment, when, by the way, they're calling each other back and forth to
Did I
arrange.
misunderstand the record? Is one of those calls at what the people's timeline indicates they would have been in the same vehicle?
Yeah, it was a less than 10-second call, and on summation, the prosecutor argued convincingly that, in the fast-moving aftermath of the shooting, the defendant probably hit the wrong contact on his phone, which I've certainly done, in non-stressful situations.
Now your light is out, if the Chief Judge will permit me this question. Slightly different thing still on this issue. So if you could, what's the rationale for this exception to hearsay, and how does your analysis ground itself in that rationale?
Well, the rationale is that if a hearsay statement is made, after a clearly startling event, and the declarant's faculties for reflection and falsification are stilled, and his statement exhibits that excitement, that it wasn't made under the impetus of studied reflection, then the statement is reliable. And I think this also speaks to Judge Fahey's point that the statement itself, that if you listen, I really would respectfully urge the court to listen to the statement, because I think the palpable urgency and excitement in the declarant's voice shows not just that the statement wasn't made under the impetus of studied reflection, but also that it was made based on personal knowledge, and the jury was well equipped to determine, based on the tone and content, whether this was personal knowledge or not. And if I could just have 30 more seconds, Your Honor.
Please.
The last words that, of course, in addition to the cell site evidence, we also have surveillance video showing the defendant or the shooter touching the outside of the passenger side door, and the police recovered the defendant's right index fingerprint from exactly that location, which is powerful circumstantial evidence of guilt. But the last word that the jury heard about this was the judge's instruction, which reminded the jurors that the declarant, or as the judge referred to him, the individual in the background of the 911 call, was unidentified and didn't testify in court, and then modifying the standard charge, urged the jurors to consider the evidence or lack of evidence of 9 different factors that bear upon the reliability and the accuracy of the identification. So the judge repeated the phrase "or lack of evidence" fully 9 times, and the jury was well equipped to decide whether or not the statement was based on personal knowledge. Thank you very much.
counsel. Mr. Weiner?
Thank you.
You're welcome.
I think Your Honors have the question here. The question is whether, as a matter of law, the court could determine that the declarant had personal knowledge. And given the complete lack of information about this person, the incredible lack of detail in the statement itself, as a matter of law...
So does your rule lead us to a statement that unless a declarant, in this moment of being affected by the excitement of what they may have observed or what they've observed, that declarant has to say, "I saw this. I saw the following." Aren't we back to that line I think Judge Stein had asked you about?
No.
Isn't that very different from the current rule we have?
We're not advocating that rule, but there has to be something that the court can hang its hat on.
You may not expressly be advocating it, but it seems to me you may be taking us down that road.
So, for example, if the declarant had described something specific in the statement that was corroborated, that might be enough, but we don't have that here. There's no detail here that's corroborated elsewhere in the evidence. It's this bare statement, "It was Twanek." It's not, he has a gun and other people saw a gun. He's driving this car, other people saw that car. Nothing like that here.
So if instead of, "I saw Twanek shoot the victim," whatever, if he just said, "Twanek had a gun," what about that one?
That would be a lot closer. That would be describing something specific, especially if it was corroborated by other evidence that showed a gun. But we don't have that here at all. We don't have that. It's just this bare statement out in the ether. And to get to harmlessness, this absolutely was not harmless. The prosecution's case was nowhere near overwhelming. This was the only direct evidence implicating Mr. Cummings in the crime. I point out that at the first trial, when this evidence didn't come in, there was a hung jury. Even in this case, the jurors deliberated for 2.5 days. They acquitted Mr. Cummings of all of the attempted murder counts. This was clearly a close case. And I'd also just refer your honors to the prosecutor's summation, which began by playing this tape twice in a row. He played it once, he stopped, and then he asked the jurors to listen to it again. And then he ended his summation by playing it a third time. Clearly, this was the crucial piece of evidence in the prosecution's case. Thank you,
Thank you,
Your Honors.
counsel.